We're going to be talking about legality and public policy in this area. There are some agreements that are considered to be unenforceable. So even if you have the offer and the acceptance, the agreement is not going to be enforceable. And here in this area, it's unenforceable because it could be a formation or performance of the contract or the agreement is a crime or a tort. Or it could be that to enforce it would violate public policy. And public policy means things that society considers to be important, or it's unconscionable or unfair. So these agreements are not enforceable in court. Illegal agreements, ordinarily an illegal agreement is void, which means it's without any legal effect. And neither party can sue on the agreement because it's void. So even if a contract appears legal on its face, it may be unenforceable if it was entered into for an illegal purpose. Legal parts of an agreement may be enforced if they can be separated from illegal parts of the agreement. So a court will ignore an illegal provision if it may be ignored without defeating the contract's basic purpose and enforce the rest of the contract. A court will assume that a contract legal interpretation over an illegal interpretation of the contract if there is varying interpretation. So if the contract can be interpreted legally, the court will interpret it legally. An agreement that calls for the commission of a crime is illegal and therefore void without any legal effect. An agreement that calls for the commission of a tort, some civil harm, is illegal and therefore void. Every contract has an implied covenant of good faith and fair dealing. This imposes an obligation on both parties to not do anything that will result in the destruction or injury of the other party's right to receive the benefits of the contract. A court may hold that a contract or contractual provision is unenforceable because it is unconscionable or without conscience or unfair. Examples of unconscionable contracts include clauses that give too much of an advantage to one party or clauses that are too harsh or oppressive. The determination of unconscionability. Some jurisdictions require both procedural and substantive unconscionability to void the contract. So the process is unfair and also the substance or what's in that contract is unfair. Other jurisdictions only require one. Procedural unconscionability relates to matters of freedom of assent, resulting from inequality of bargaining power and the absence of real negotiation, and meaningful choice or surprise resulting from hiding a disputed term in an unduly long document or fine print. So contracts of adhesion, contracts offered by a dominant party to a party with an inferior bargaining power, a take it or leave it basis, would be an example of a procedural unconscionability or contract that is procedurally unconscionable. Substantive unconscionability. Substantive unconscionability is indicated when the terms of the contract are so one-sided as to shock the conscience, or so extreme as to appear unconscionable according to the business practices of the time and place. Agreements affecting public welfare. Agreements that harm the public welfare are not binding. These include, but are not limited to, agreements that interfere with public service, agreements that obstruct legal process, and agreements that unlawfully discriminate against classifications of individuals. Agreements contrary to public policy. A court will not enforce an agreement that may not violate the law, but that is still so offensive to society that it should not be enforced. Public policy equals certain objectives relating to health, morals, and integrity of government that the law seeks to advance, by declaring invalid any contract that conflicts with those objectives, even though there is no statute expressly declaring such a contract illegal. Courts are cautious in invalidating these agreements because the standard is somewhat vague and such a ruling restricts freedom of contract. Statutory regulation of business contracts and the effect of a violation. Whether an agreement made in connection with business conducted in violation of the law is binding or void depends on the public policy of the prohibited act. In order to avoid these violations, certain state statutes provide that all contracts of a given subject matter must follow a statutory model or contain specified provisions. License callings or dealings. If a professional license is required by statute to protect the public from unqualified persons, a contract made by an unlicensed person is unenforceable. Contracts in restraint of trade. An agreement that unreasonably restrains trade is illegal and void on the ground that is contrary to public policies. Examples include contracts to form monopolies, price fixing contracts. Agreements not to compete. Restrictions to prevent competition by a former employee are valid when reasonable and necessary to protect the interests of the former employer. A non-competition covenant may be held invalid because of vagueness concerning the duration and geographic area of the restriction. The agreement was not properly executed in accordance with state law. In the agreement, it places a restriction that is broader than reasonably necessary to protect the former employer. So these are reasons that a non-compete may be held invalid. The effect of invalidity of agreements not to compete. Some courts will use the blue pencil rule, which modify the agreement to a scope that is deemed reasonable. Other courts hold that the covenant or the entire contract is void.